Hello viewers, Assalamu alaikum. This is Mairul Islam.
And this is Chirajit Dashami.
Welcome to our presentation.
Our presentation topic is human rights to be protected from arbitrary arrest and detention. Viewers, today we will discuss about the basic concept of arbitrary arrest and detention, background of it, definition and elements of this arbitrary arrest and detention, arbitrary arrest and detention in the national law and international law perspectives, scope and content of arbitrary arrest and detention, contemporary arbitrary detention in national law, constitutional safeguards, rights, contemporary content of Bangladesh Act about controlling the violation of these rights, and finally our suggestion. Actually, it's not our suggestion. It can be said that the request to the government for improving this condition.
In this presentation, we will try to provide a brief overview of the freedom from arbitrary arrest and detention in international human rights law. Right to personal liberty and security and freedom from arbitrary arrest and detention are coming under the purview of human rights, whether it is under the domestic law or international law. The right to personal liberty required that the person not to be subject an arrest and detention except as provided for law, and provide that whether the arrest nor detention is arbitrary. Whether appropriate law should provide for safeguard to ensure that they are not exercised in arbitrary manner. Safeguard might include that the right to challenge the lawfulness of detention and supervision by the judicial officers. Actually, the concept of this right is derived from some example of the arbitrary arrest, where it is found that virtually all individuals who are arbitrarily arrested are given absolutely no explanation as to why they are being arrested, and they are not shown any arrest warrant. Many individuals who are arbitrarily arrested and detained suffer physically or psychologically torture during the interrogation, as well as extrajudicial punishment and other abuse in hand of those detaining them. Arbitrary arrest and arbitrary detention are the arrest or detention of an individual in case which there is no likelihood or evidence that the committed a crime against legal statute, or in which there has been no proper due process of law. Actually, when someone kept in custody without proper due process of law, despite the fact that he or she committed no offense, it is called arbitrary arrest or arbitrary detention. First element is offender is a public officer or employee. Second, he detained a person. And third, the detained is without legal grounds. Here the legal ground is no crime was committed by the detained. Second, there is no violation instantly of the detained person. And thirdly, the person detained has no ailment which require compulsory confinement in a hospital. The right to security of a person and freedom from arbitrary detention is contained in Article 9 of UDHL. Article 9 also provides a number of other rights for the person who are arrested and detained. Article 9 of the International Covenant on Civil and Political Rights declare as everyone has the right to liberty and security of a person. No one shall be subject to arbitrary arrest or detention. No one shall be deprived of his liberty except such ground and in accordance with such procedure as established by law. Then, anyone who is arrested shall be informed at the time of arrest of the reason for his arrest and shall be promptly informed of any charge against him. International law and jurisprudence has come a long way from the first series of European texts, the Magna Carta, the Habeas Corpus, the Act of England, and the France Declaration of the Rights of Man and the Citizen, that introduced the concept of the freedom from arbitrary arrest and detention. When Article 9, Subarticle 1 of the ICCPR refer to the requirement that the deprivation of the liberty to be prescribed by law, it means that the law must be acceptable, understandable, non-retrospective, applied in the consistent and the predictable way to everyone equally, including authorized, and be consistent with the applicable laws. Bangladesh is a country where the supremacy of constitution is prevalent in every shaper of human life. The Constitution of a People Republic of Bangladesh has mandated to its people to be free from all form of arbitrary action, threatened arrest and torture, also detention. However, the use of torture and inhuman degrading treatment in custody is a common incident against the right to life, liberty and dignity in our Bangladesh. The violation of this right are mostly caused by the arbitrary exercise of power by the state law enforcing force. Most of these abuse incidents remain the unaddressed and not reported duly in justice process. And the right against the arbitrary action and the right of privilege of a person accused. In modern legal system, these include the presumption of innocence until proved guilty, trial by jury, representation by the counsel, the right to present witness and evidence to establish one's innocence and the right to cross-examination one accuser.
Bangladesh is a country where the supremacy of constitution prevails in every sphere of human life. The Constitution of the People Republic of Bangladesh has mandated to its people to be free from arbitrary action and provides safeguard against the torture, ill treatment, arbitrary arrest and detention. Actually, Article 27 and the other articles such as Article 31, Article 32 and 33 provides the safeguard against arbitrary arrest and detention. In details, if I want to say in details, Article 27 establishes the rights, equality before the law. Article 31 provides protection of law and prohibits the action not taken in accordance with the law. Article 32 protects the right to life and personal liberty. If we specially describe the Article 33 of the Constitution confers 3 constitutional rights upon the personal arrest. Clause 1 and 2 states that he or she cannot be detained in custody without being informed as soon as may be the right of the grounds of his arrest. He or she has the right to be produced before the nearest magistrate within 24 hours and cannot be detained in the custody beyond the period of 24 hours without authority of the magistrate. And he or she has the right to consult and to be defended by the legal practitioner of his choice. And clause 3, 4, 5, 6 deals with the 3 constitutional safeguards against the detention. In this part, we will see that if the law violates the natural justice of human rights, what will be the happen. So now we will discuss about the commentary of arbitrary detention in national law, human rights in contemporary content in Bangladesh, and especially the Special Power Act 1974, the arbitrary exercise of the power in Bangladesh. So actually, arbitrary arrest, detention and torture cruelly are few common phenomena as we have seen regularly in our daily newspaper and electronic media. Firstly, in Bangladesh, without trial, 6-month detention can be conferred to the detainee. It's not applicable presently anywhere, not even in India and Pakistan. Secondly, preventive detention is method restored to the emergency or during the war in USA and UK and Singapore. But there is no specification in our constitution. That's why it can be restored even in the time of peace and emergency period. Thirdly, there is no fixed and maximum period of the detention in our constitution or under the Special Power Act of 1974. So actually viewers, you know, there is a Human Rights Commission in Bangladesh, so they have a plan about the human rights and about this arbitrary detention, arbitrary arrest and detention. So what are the plans? So actually the plans are industrial development, pressing human rights issues, human rights monitoring and investigation, human rights promotion, education and awareness raising, human rights resource reporting and policy development. So actually we are reaching the concluding part. In the concluding part we want to provide some suggestion. Actually it is not suggestion, it can be said that request to the government for improvement this condition. So the requests are to ensure transparency and accountability of actions to the police authorities. It is imperative that the directives of the Supreme Court in the Blast versus State case as Saifujaman versus State case should be implemented as soon as possible. Revoke the Special Power Act 1974 to be protected the citizens from arbitrary arrest and detention, and please don't use this arbitrary arrest and detention as a political weapon.
So viewers, we will try our best to make you understand.
Thanks to all for being with us.